Your Honor, I'll announce. I didn't expect to be here today because I thought a deposition was going to be ongoing, but it canceled. My name is Adrian Sinishin, and I'm the counsel for Patriot Services Network. Mr. Zamora prepared, so he's going to do the heavy lifting on the motion.
Okay, great. All right, thank you, counsel. Okay, we're gonna go back to the top of the docket for our first case, Colvin. Mr. Beige, were you able to reach plaintiff's counsel?
By way of report, Your Honor, we were in communication with Mr. Klein, and he was in the waiting room and somehow wasn't let in, so he logged off, and he's now logged back on, I understand, and he's waiting to come in, or at least
he's maybe in a waiting room. He's yeah. Not in our waiting room.
Make sure he's in this.
He's joining that meeting that you guys
we're talking to him right now, so
yes, that's what
did he use the right number? Because the court says he's not in there. I apologize, Your Honor.
Okay.
But he should, I mean, like I said, it will be a quick. He says they're using it. I don't.
Okay. It's at 969-09-18-82-61, right? And it's showing that they need to let him in.
He must.
He's going to click again and see if it's.
He's going to click it again. They're from Houston, Your Honor. I don't know.
Well, they have email in Houston. Last time I checked.
Oh no, they have the instructions, and they punched in the Zoom code, and they feel like they're in the room. They may succeed. I think now.
Okay.
That we're helping them.
Okay. His assistant is going to run.
There he is.
Yeah, his assistant went down to help him. Thank you for your patience, Your Honor.
Sure. All right, Mr. Klein?
Yes. I apologize, Judge. We had some technical problems this morning.
Okay, that's all right. Your clients and everyone else are here, so we can get going now that you are here. If you're here on the second or third hearing, can I get you to turn your video off until your case is called to minimize the number of screens we are looking through? Thank you. All right, we will go on the record in cause number GN23-007380, Colvin versus Outlaw Paintball. Counsel, you may proceed.
Your Honor, I'm Scott Beige, guardian ad litem for the minor plaintiff. I'll let the other two lawyers announce.
Alex Klein for the plaintiffs.
Vernon Elkins for defendant Outlaw Paintball.
Your Honor, we're here to provide testimony in support of the minor settlement that's before the court's consideration and for the court's approval to enter approve the settlement agreement, the release and indemnification agreement, and hopefully enter the agreed final judgment today. And with that, I'd like to put on testimony by both the next friends and parents of the minor plaintiff, Eve Colvin and Richard Colvin, and I'd ask the court to swear them both in.
Thank you. All right, Mr. Beige, you may proceed.
Thank you, Your Honor. Richard, I'm going to take you first. Please, your name is Richard Colvin, correct?
That's correct.
And you're married to Eve Colvin?
Yes.
And what is your son's name? And he was involved in an incident on or about January 15th, 2023. Is that correct?
That's correct.
And he was injured at a facility known as Outlaw Paintball in Austin, Texas?
Yes.
And he received an injury to his right eye, correct?
Yes.
And you hired Alex Klein of the Klein Law Firm to represent you and your wife and your son in this case, and you have reached a settlement in this case, correct?
That's correct.
you understand this is a confidential settlement?
Yes.
And I've sent the court a settlement confidential package memorandum for the court to see in camera. But I'm going to ask you some general questions about the release and indemnification agreement, so that the court knows that you understand the terms of the settlement. I can't mention the numbers on the record, though. Do you understand that?
Yes.
Okay. And of course, the confidentiality is there for your own protection and for your son's protection as well. So I approve of that as the guardian ad litem. So first of all, have you subject to the court's approval, have you and your wife executed the release and indemnification agreement?
Yes.
Okay. And has the terms of the release and indemnification agreement been explained to you by your attorneys at the Klein Law Firm?
Yes.
Okay. And you understand the attorney's fees that have been taken, the expenses that have been taken, the subrogation interest that was asserted and was reduced greatly in this case?
Yes.
Okay. And do you approve of those fees and the expenses, and obviously the reduction of the subrogation fees?
Yes.
And you understand that as a result of that release, if the court approves of this, the release and indemnification agreement, that this will constitute a full and final release against Outlaw Paintball and all their employees, agents, insurers, administrators, agents, anyone associated with the defendant.
Yes.
And that means that no matter what you should discover with regard to Eli presently or in the future, it doesn't matter. This will be the end of the case. You can never come back and sue the defendants or their agent, servants, or employees or insurer for anything arising out of this incident.
Yes.
It's my understanding he's back at school. His left eye is you can see has excellent vision out of it, correct, as we discussed? And he's in school. What grade's he in?
Going into 6th grade.
Okay, he's an excellent student, correct?
Yes.
And you are both you and you're employed in the tech industry.
That's correct.
And you have good insurance coverage.
At the moment, yes. Mm-hmm.
Yeah. And your wife's also employed.
Yes.
And she could have insurance coverage if she wanted to too. I think you all use yours.
Correct.
Okay. And so the decision was made to take after the deductions that we talked about, to take the entire amount that was remaining and to place it in a structure settlement with periodic payments for Eli. Is that correct?
Correct.
And so you, with the type of grades that Eli is making and continues to make even after this incident, you expect him to be college bound. And so you've set up a college fund that gives him biannual payments for under the structure. Just, and I'm not going to say the amounts, but the period of time is 2 payments a year for 8 years, correct?
That's right.
And then he also will receive lump sum payments beginning at age 25 and age 30 and 35 and age 40, and then a really substantial payment at age 45. And you recognize that, correct?
That's right.
And you were given other proposals to consider, and we went through that process, and you worked with Hanson Street of the James Street Group, correct?
Correct.
And you and your wife felt it was in Eli's best interest to pick that particular structure because you wanted to make sure that he went to college, but you wanted to make sure that he received his funds with maturity firewalls and the greater amount of his funds when he was older and more mature and better able to handle the money.
That's right.
Okay. And so you understand that if the court approves this settlement, you will be waiving your right to a jury trial, and that you could have brought this case before a jury and you could have gotten more, you could have gotten less, but you felt it was in the best interest of your son to go ahead and reach this settlement.
Correct.
And you understand that the same applies with the defendant in this case, correct? That they decided to waive a jury trial, and that both sides have decided to make this decision because of the risk that's involved in any type of lawsuit. No one's making an admission that you're not making an admission that you don't think you have a case, or that the defendant's not making an admission of any liability by settling this case, but everyone's recognizing there's risk and they want to reach a settlement and buy peace in this case, correct?
Yes.
Okay. you agree and endorse the structured settlement, and you totally understand? Did you hear what I asked you, sir?
I did, yes. I think another.
Dr.
Yeah.
Evans is muted now, so that won't happen again.
Sorry.
You agree and endorse the structured settlement with the AM Best plus 15 rated company that we went through?
Yes.
Okay. And you don't have any questions with regard to this settlement? You understand it totally? I've met with you and your wife, and I've answered your questions?
Yes, no questions.
Okay. And you believe it's in your son's best interest?
Yes.
And are you asking the court to approve the release and indemnification agreement?
Yes.
And are you asking the court to enter the agreed judgment that's before the court today, approving the settlement, bringing this case to a close against Outlaw Paintball, and that will be the end of the case?
Yes.
And you totally approve of the services that were rendered by the Klein Law Firm and Alex Klein?
I do.
I have no other questions, Your Honor.
Okay. Counsel, anyone have any questions for Mr. Colvin?
No.
We have no questions for him at this time. Thank you, Your Honor.
With your permission, Your Honor, I'd like to ask Eve Colvin a few questions.
Absolutely. Go ahead. Ms. Colvin, if you would unmute.
Ms. Colvin, you're Eve Colvin, correct?
Yes.
And you're married to Richard?
Yes.
And you heard you're Eli's mom?
Yeah.
Correct? And you heard all the questions I asked Richard?
Yes.
And do you agree with all his answers?
Yes.
In particular, I want to be sure so it's on the record and clear. Do you understand that if the court approves this proposed settlement with Outlaw Paintball, that neither you nor Richard nor Eli will ever be able to come back and assert any claims against Outlaw Paintball for any injuries that Eli sustained on or about January 15th, 2023, and that this will be the end of the case, and that they will be the defendant and their insureds and their agent, servants, and employees and officers will be completely released. It'll be the end of the case, no matter what.
Yes.
You understand it's a confidential settlement?
Mm-hmm. Yes.
And you signed the release and indemnification agreement?
Yeah. Yes.
It was explained to you and you understand it?
Yes.
And you also agreed and understand with the attorney's fees, the expenses, and the reduction of the subrogation interest? And you also agree with the structure that we came to, that we described?
Yes.
Do you believe this settlement is in the best interest of your son, Eli?
Yes, I do.
And I've answered all your questions, and your attorneys have answered all your questions with regard to this settlement?
Yes.
And so are you asking the court to approve this settlement because you believe it's in your son's best interest?
Yes.
And are you asking the court to enter an agreed judgment which endorses the settlement and release indemnification agreement and ends the case?
Yeah. Yes.
Okay, that's all the questions I have, Your Honor.
Mr. Elkins, Mr. Klein, do either of you have any questions for this witness?
No
We have no
question.
additional questions, Your Honor. Thank you.
Okay, thank you, Ms. Colvin. All right, Mr. Page, let me take a moment to thank you for submitting the package of information to the court for my review before this hearing. That was very helpful. I do need, if you wouldn't mind resending the agreed final judgment with the signatures of counsel. The version that I received does not have those.
We'll send it to you immediately, Your Honor.
Great, thank you. And Mr. Elkins, on behalf of your client, the defendant is in agreement with providing payment to the guardian ad litem, Mr. Beige, for his services rendered on this case.
Yes, Your Honor.
Okay. All right. And anything else to add to what the court has already heard, counsel?
No, Your Honor.
No, thank you.
Other than obviously I recommend and endorse the settlement. And as I've stated in my published as well as my confidential memorandum to the court.
Okay.
And I will immediately have my assistant send the final judgment that has been signed to the court right now, for the court signature. I apologize. I thought it had been sent to you already.
Okay, well, the version that I have it omits the signature. So since it is an agreed final judgment, we would like a version that has everybody's sign off on it. To the Colvins, I am sorry to meet you under these circumstances. I understand that by everything you've told me, that you believe the settlement to be in your son's best interest. The guardian recommends it and believes the same. And so based on what I've heard here today, I will approve the settlement and enter the agreed final judgment that's been sent in. So I am glad to hear that you've reached a resolution to bring the case to a close and that your son, considering all things, is doing well now. So.
And thank you.
All right. That will, I think, conclude our work on that. As soon as we receive it, Mr. Beige, we'll get it signed and over to the clerk. So y'all are excused from the virtual courtroom.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. Chi versus Sanchez Electric Work et al. Go ahead with your appearances, counsel.
Ernesto Sigmund on behalf of the plaintiff, Stanley Chi.
Good morning, Your Honor. Robert Collins on behalf of defendants In Charge Electric and Seth Robinson.
Morning, Your Honor. Cayman Angel here on behalf of Efrain Well Guzman Perez.
Okay. Which motion are we going to take up first?
We can take up the motions to strike and exclude, if that's okay.
Whatever the court prefers, Your Honor. Our motion to strike plaintiff's affidavits was filed first. We had previously set a hearing for it, but it was my office's fault that we didn't comply with the court's requirements, so we had to get it reset. So whichever order the court would like to take it in is fine with this defendant. Thank you.
Okay, Mr. Sigmund.
Agreed. Whatever,
Okay.
Your Honor. It's fine.
All right. Well, we'll start with the first file then. That's fine with me. Go ahead, counsel.
All right. Thank you, Judge. Let me just pull that up real quick. We have filed, defendants In Charge and Seth Robinson have filed a motion to strike plaintiffs' billing affidavits under 18.001. That motion was filed on April 28th of this year, just to provide the court a little bit of background related to that. My clients were brought into this lawsuit later than some of the other defendants. In Charge filed its answer in this case on July 1st of 2024. Mr. Robinson filed his answer on July 17th of 2024. And I'm sorry, Your Honor, just to back up real quick, this lawsuit relates to an automobile accident that happened on June 12th of 2022. My client is two of those defendants. So we filed appearances for my clients in 2024. July of 2024, under the Civil Practice and Remedies Code, plaintiffs' medical and billing affidavits, or plaintiffs' billing affidavits were due to us 90 days after we filed our answer in the case. That would have been September or October of 2024. The plaintiff did not produce any notice of filing of affidavits in this case until March of this year of 2025. But to provide the court a little context and background, back in December of 2024, the plaintiff had filed a motion for entry of docket control order, motion for entry of trial setting with the proposed docket control order. And we didn't agree on a docket control order back then because the plaintiff had a deadline in his scheduling order that allowed for the disclosure or the filing of plaintiff's 1801 affidavits in April. And we said, we can't agree to that. You've missed your deadline and you still haven't produced these records to us. So we went forward with a hearing in front of Your Honor back in December. And at that hearing, we again objected to the plaintiff's scheduling order because we said he has not provided these medical and billing affidavits under 1801. He hasn't filed a motion for leave. He hasn't shown the court good cause as to why these are still delayed. And so on January 30th of this year, Your Honor entered a scheduling order in this case that did not have a specific 1801 affidavit deadline for plaintiff or defendant. And so it reverts back to the plain language of the statute that the plaintiff was required to produce his affidavits to us by the earlier of 90 days after the defendant files his answer. The date the party must designate a witness in the case, or a date the party must designate a witness pursuant to a scheduling order. And so we have a scheduling order in this case that Your Honor executed March 28th, 2025 was the plaintiff's expert designation deadline. The plaintiff waited until March 28th of 2025 to file his notice of filing of affidavits, but that's not when they were due. Under the plain language of the statute, Your Honor, they were due 90 days after we filed an answer. They weren't produced until March of 2025. So preliminarily, my position is they're right now, as we sit here, they're not admissible before the court because they were not timely filed. But then more to the point, the plaintiff has had at least since January, really since our December hearing, to file a motion for leave to file these affidavits to show the court good cause why he has not. And so if he would have done that up to any point before his March 28th, 2025 expert deadline, you know, I could see a theoretical argument as to why they would be allowed, but he didn't do any of that. He waited until the deadline without first seeking leave of the court and establishing that requirement. And so my argument to the court is now is, and also, Judge, he has not filed a response to our motion to strike as best I can tell. So, you know, the summary of the argument is his 1801 affidavits are, as a matter of law, untimely, and so they should be excluded. And the plaintiff hasn't taken any affirmative steps with the court to seek leave to allow them to now come into evidence. That's the gist of the argument, Your Honor. So we're asking that all of the untimely affidavits that plaintiff has produced in this case be struck under 18.001.
Okay. Mr. Sigmund?
Yes, Your Honor. Well, this case has experienced a lot of flux. And so when I came into the case, the answer deadlines that were referenced by Mr. Collins had passed. I identified the expert designation deadline as the deadline that we needed to make sure that we disclosed our affidavits. And that's the deadline that I hewed to. I do recall the hearing where I was advised that, you know, things had not been produced. I think that counsel is potentially coloring this as us being evasive or something like that. That's not the case. If the court deems otherwise, we just will respectfully request leave to properly and timely file them. But we filed them. He's got them. He's got the records. We want to make sure that everybody has everything that they need to properly evaluate the case.
Okay.
Do you want a response, Your Honor?
Sure.
Okay, so he acknowledged we brought it to his attention in December. He knew that the court excluded his original proposed deadline. He's asking for leave today. That's not the right way to do it. He needs to procedurally seek leave from the court and establish to the court good cause as to why it hadn't been done yet. So at least as it relates to, as we're sitting here today, I would ask that the court sustain our motion to strike the subject affidavits. Thank you.
And Your Honor, what I would humbly and respectfully request is if the court finds that it's excusable neglect, perhaps leave could be granted on that basis. But the reality is that when I came into the case, I didn't realize that this was going on. Just being totally transparent and candid, and tried to do the best that I could to meet the deadline to disclose the information as required. So.
Okay, well, a motion for leave isn't on file, hasn't been set for a hearing, and I really haven't heard anything that's in the realm of what I think good cause would be. So I'm going to stick to the motion that's on file, the one that has been set for hearing today, and that's the motion to strike. It's granted.
Thank you, Judge.
All right, let's move on to the other motion.
We filed a motion to strike the expert testimony of the defendant's experts that were designated recently. I'll start off with the motion to strike the testimony of Angela Vanderwerken, PhD. And Judge, you might have to direct me on the choreography with Box. This is my first time doing this in this jurisdiction. So do I just make a reference to the exhibit, or should I share my screen, or how does that work?
So Box is for the court reporter. It's if we were in the physical courtroom, you know, prior to technology, you would hand the court reporter a physical exhibit, but Box is a electronic exhibit system. So if you have something in Box that you want to offer into evidence, you can do so. If you want me to simply be able to view it, you can share your screen.
Perfect. Thank you very much.
Sure.
So Dr. Vanderwerken was retained as a billing expert in this case. And as you know, you clearly understand the requirements, the statutory requirements for an expert witness per Rule 702 and others. But the main issue that we have with Dr. Vanderwerken is we have concerns about her qualifications. We also have concerns about her methodology. And we also think that the counter affidavit that she filed doesn't pass muster with regard to the requirements of 18.001. So I'll share my screen first of all with plaintiff's exhibit number 1. This is Dr. Vanderwerken's CV, and nowhere in the CV does it talk about billing or coding expertise. She is an economist, and nowhere in her CV does it discuss really any of the extensive certifications that many other experts have with regard to billing and coding. In fact, her only certification is an online certification that she received as a specialist for payment and reimbursement. So Dr. Vanderwerken was essentially retained to challenge the medical bills that my client received at 5 different healthcare facilities. The first one was to Austin Total Healthcare, Central Texas, physical therapy, Christus Santa Rosas, and then of course medical injury rehab specialist, and then strategic healthcare. Each of the affidavits that Ms. Vanderwerken submitted, and I'll pull one of these up as an example, we think contains a fatal flaw. So if I go to plaintiff's number 2, and again, I'll share my screen. So, and pardon the scrolling, Your Honor, but this is the affidavit, one of the affidavits submitted by Ms. Vanderwerken, and this one pertains to Austin Total Healthcare in 2022. And it goes through setting up, you know, her position and qualifications and things of that nature. But the fatal flaw appears on page 4 of 12, and this is going to be in all of her affidavits. She says, I make these assumptions in my analysis. I was not asked to analyze the medical necessity or relatedness of the services received, and I express no opinion. So in our estimation, that's fatal, given that plaintiff's affidavits do address and talk about what's reasonable and also what's necessary. So the fact that she acknowledges that she's not offering an opinion on medical necessity, we think is a huge problem and grounds for her to be excluded. At the time that we filed the motion, we had not deposed Ms. Vanderwerken, but in the interim, we were able to depose her. We got the transcript literally a couple of days ago, and I'd like to just direct your attention to a couple of excerpts from the deposition that'll give you a flavor for our exchange.
Well, and Your Honor, I'm sorry to interrupt.
Well,
I mean, I'm going to object to any evidence that Mr. Sigmund is attempting to introduce today that hasn't been timely supplemented in his response or provided to my office. Our office has filed a reply to this, and his motion says, hey, we will supplement with deposition testimony when it becomes available. It's not fair to me to have to respond on the fly today to something I'm not prepared to respond to. So just make that objection for the record, Your Honor.
Okay, Mr. Sigmund, when was the deposition taken?
Pardon me, Your Honor, let me get back to where I was. June 20th?
Okay, and I presume counsel for all parties were present at that deposition?
Yes.
Yes, Your Honor.
All right, I'm going to overrule the objections, Mr. Collins.
So,
You
and
may proceed.
again, I'll share my screen, and this is going to be, this is actually plaintiff's 14. Hopefully it doesn't cause any confusion. But this is an excerpt from Ms. Van der Werken's deposition, and I asked her, I said, well, do you think it would be helpful for you to get some of the certifications? This is pursuant to a conversation about all of the standard certifications that billing experts hold. We went through each one, had a very detailed conversation about each one, and it was news to her as to what some of the certifications actually established or certified. So then I said, well, do you think it would be helpful for you to have some of these certifications if you're going to continue as a billing expert? She was like, I don't plan to. And she went on to say that as an economist, she's an expert in pricing. Well, that confused me because I said, well, pricing is not the same as billing, is it? And she gave a vague response about the definitions. And I told her, frankly, I said, I'm confused. I just asked you if pricing is the same thing as billing. And so her answer there was conclusive. And then she goes further, where I asked directly, so are you a pricing expert or a billing expert? And she proceeded to say that she could opine on the reasonableness of bill charges and of payments, again, without the necessity component. And then the pricing can include both of these things. And so I asked her, frankly, I said, do you understand that your role as an expert is going to be to help a fact finder, her 702? And she acknowledged that she did. And so then I said, well, do you understand that part and parcel of your function is to help them clearly understand certain aspects of the case, specifically billing? And she said that she did understand that as well. I wasn't convinced. And so further, I asked her, quite frankly, well, can you tell me what paid or incurred means? And the substance of her response, I feel, is wanting because to me, it wasn't an articulate response as to what that is, which I think is something that's fundamental. So in light of all of those things, when we take them together, and I'll stop sharing. When you take them together, we think that it's disqualifying. I could go through each affidavit and demonstrate that same language where she says she's not talking about necessity, but for the sake of efficiency, I will just represent to the court that it's present in each of her affidavits.
Okay.
And we have her report available, but Your Honor, it's voluminous, and so I didn't necessarily want to pull it up and scroll through that much because I didn't want to disrupt the court. So.
Okay, well, I read the motion and the response prior to the hearing, so I have a general idea of what the complaints are.
I see. That's all I have.
Okay, Mr. Collins.
Thank you, Your Honor. So just a couple of points on Dr. Van der Werken. Preliminarily, as I understand plaintiff's argument today, notwithstanding what's in his pleadings, he's saying that Dr. Van der Werken should be excluded because she's not opining on medical necessity of treatment. She is not a medical doctor. Her sole focus in this case was related to the medical charges. Both my clients and co-defendants have retained other medical experts to opine on reasonableness of treatment and medical necessity. So that has her opinions that she's not making, her statement that she's not having, doesn't have any opinion on medical necessity is completely irrelevant to her designation in the case, number one. The second argument they made today is that in her deposition, he believes that Dr. Van der Werken did not give an articulate response to his question. And again, I did not have those highlighted portions, but I just quickly wrote down, he says that she gave conflicting statements regarding price and cost. And I was just able to quickly write down that she had said, well, pricing can include both of those items. And then she goes on to say, I'm something like I'm an expert qualified to opine on this because I'm an economist. So just as it relates to those oral arguments today, medical necessity has no relevance to her testimony. And, if he thinks it wasn't articulate, she still gave a response. Okay. Right. And so preliminarily that's that. And so what the plaintiff has done is he's filed a motion to strike her controverting affidavits under 1801. And he's also filed a motion to just exclude her, I guess, as an expert. And so my position here is I have two bites at the apple to get her opinions and testimony. And first, under 1801, all that is required under the statute is that the affiant be qualified by training, experience. Let me pull up my, make sure I read this right, Your Honor. So two steps under 1801. First is the affiant qualified. That's the first requirement. And the statute says that the counter affidavit must be made by a person who is qualified by knowledge, skill, experience, training, education, or other expertise to testify in contravention of all or part of any of the matters contained in the affidavit. And then the second part is give reasonable notice of the basis. And so preliminarily, I want to focus on that first element under the 1801 analysis is her qualifications. The plaintiff's motion to strike makes a very broad boilerplate assertion related to the specific qualifications, but her report was provided, and Your Honor had indicated that you had read the materials. Her report and her CV show that she's qualified. She's an economist. She has education, training, and experience. She holds a PhD in economics. She's a member of the National Association of Forensic Economists. She does have a certification related to payment and reimbursement codes. The plaintiff seems to think that because she got it through an online service that it's somehow less legitimate, but hasn't showed any foundational basis for that. And so, based on existing Supreme Court precedent from Gunn, In re Allstate, she's qualified based on her experience, training, and expertise. The second component of that under the 1801 statute is her affidavits have to give reasonable notice of what she's addressing. And as Mr. Sigmund noted, her counter affidavits and report are voluminous because she gets into the specifics of every component of what she is doing and how she is doing it. She provides her methodology. She sets forth the charges that were identified by the plaintiff. She identifies based on methodologies that kind of piggyback onto the expert analysis how she comes up with usual, customary, and reasonable charges. She provides her methodology. She provides the sources of the data that she used to come up with those opinions. She goes through a step-by-step analysis, and she notes that her opinions are based on existing treatises and journals accepted in the industry. And so, the 1801 issue and the expert issue are commingled. So a lot of these arguments regarding her qualifications and reliability are the same. But just under 1801, all the counteraffiant has to do is set forth her qualifications and provide a reasonable basis for her opinions, and the affidavits do that. And so I would argue first, just under the 1801 analysis, that her counter affidavits are admissible.
Okay, well, let me ask you about that, Mr. Collins, because now that the court has struck plaintiff's affidavits, do the counter affidavits come in? Because I have an opinion on that.
No, I do. That's excellent. Thank you for reminding me of that, Judge. I was going to bring that to the court's attention. So in the totality of the case, plaintiff has 8 medical providers. She controverted 5 of them. There is, I believe, 1 or 2 sets of those 8 medical records that the plaintiff did timely file. So there are still like two sets based on the court's ruling today. There's still two bills out there that I would say that the plaintiff would have the right to present, and those have been controverted by Dr. Vanderwerk. And so while it may be moot on some of those as it relates to the two that are still in play, I guess I would say her affidavit testimony on that would still come in. If the court maintains its position and keeps those other records bills struck, then yeah, it's a moot point.
Okay. All right, Mr. Sigmund, anything else with reference to this doctor?
Nothing further, Your Honor. Well, PhD.
Those are still called doctor, I think.
Your Honor, as I said, he's attempted to strike her 1801, but then also her testimony. Just very briefly, I'm not going to rehash it. For the same reasons that she's qualified under 1801, she's qualified under an expert analysis. Her report set forth her opinions, the methodology on which it was based. Clearly, her testimony is relevant because we're fighting about plaintiff's claims for past medical expenses. So just briefly under that analysis as well, I argue it is her testimony is admissible. Thank you.
Well, and if I may, Your Honor, just very, very briefly, that it's my conclusion statement. Ms. Vanderwerk is not a billing expert. She's not a coding expert. The methodology that she talks about in her reports are extremely vague. We talked about that during her deposition. She picked an 80th percentile and wasn't able to explain how she selected it, nor could she explain the statistical significance of it. And she didn't even want to disaggregate the number or even talk about alternatives. And we also had an exchange about where she gets her data, because my thought was that she's simply regurgitating data from databases that aren't applicable to this case, specifically Medicare and a couple of other databases that she named. And the last thing I'll say is that I examined her about her coding experience specifically because that is fundamental to this type of testimony and expertise. And she advised me that not only does she not have expertise in coding, but that when she approaches a coding issue, she has to consult with someone like a coding expert to give her orientation to that aspect. So again, I think in the aggregate, she is not going to be reliable or helpful to a jury. Thank you.
Okay. The motion as to Ms. Vanderwerk is denied. I believe that is there another motion for other parts?
Yes,
yes. There's another motion to strike the medical experts, so we're also designated. And as a caveat, none of these witnesses have been deposed yet. I'm actually deposing Dr. Evans, who I believe might be present currently. We're supposed to be speaking this afternoon. But the basis for each to exclude each of these is as follows. Let's take Dr. Muffalato first. Dr. Muffalato in his report is advocating a multidisciplinary approach rather than a surgical approach. The problem with that in our estimation is that the surgical recommendation for Stanley Chi comes from a neurosurgeon, a gentleman by the name of Dr. Judson Cook. And Dr. Muffalato is not a neurosurgeon. He doesn't do that kind of spinal surgery. And it's all throughout the records that Stanley Chi has a mild traumatic brain injury, which makes Dr. Cook much better suited to determine the course of his care and what he's going to need in terms of surgical intervention. So we think for that reason, Dr. Muffalato should be struck. And I'd like to pull up his report, which is going to be plaintiff's number 7. And I'll share my screen. So, and I asked Dr. Muffalato, well, actually I have deposed Dr. Muffalato, but I asked him in his deposition, I don't have the transcript, but I said, you've got something that's contradictory in your report. Because in your report, you're telling us that surgery is rarely indicated except for cases involving a neurological deficit or severe radicular pain. Stanley Chi has both of those things. And so in our estimation, this is inherently confusing for him to state this. And I can't understand how he can reconcile this acknowledgement with the notion that he doesn't need surgery. Because the reality is that in his own language, he's saying that surgery is rarely indicated except for cases involving a neurological deficit. Stanley Chi has a demonstrated neurological deficit as a result of this crash and his injuries. So that's our position on Dr. Muffalato. With regard to Dr. McElroy, the issue with Dr. McElroy's report is, number one, it contradicts Dr. Muffalato's report completely. And these experts are on the same side of the V, if you will. And Dr. McElroy is essentially saying that there are no acute findings of injuries for Stanley Chi, which everyone else is acknowledging injuries. So we think that that's an issue. In addition to that, Dr. McElroy has not seen or examined or been in the presence of Stanley Chi at all. In fact, none of these experts have. And I think that the severity of his injuries and the breadth of his injuries, if you will, requires that he be seen and treated by these people, especially if they're orthopedic surgeons and are bound to that code. So that's another thing that we think disqualifies Dr. McElroy. With regard to Dr. Evans, and this is going to be plaintiff's exhibit number 9. So the problem with Dr. Evans's report is that it, on its face, is mired in confusion because he says, in his opinions, he says, Mr. Chi sustained a concussion or mild traumatic brain injury in the 6/12/22 accident if he met the criteria that follow. I am not able to determine if Mr. Chi had a concussion or mild traumatic brain injury. That's fatal, we think, to his ultimate conclusion that the treatment that Mr. Chi received at the Neurodiagnostic Center was unnecessary. He's not even sure if he lost consciousness or not. So how can you, again, reconcile that opinion in that position? We think that that's disqualifying. And the last challenge is going to be to Cecilia Maria Boy Braga. And the sole basis of our challenge there, Your Honor, is that Ms. Braga is a PhD. She's not a medical doctor, and she's offering an expert opinion to, in her report, she quotes a reasonable degree of medical certainty, which is not something that she's qualified to do. So on that basis and those bases taken together, we're asking that the court strike and exclude these named expert witnesses.
Okay, Mr. Collins.
Your Honor, I'm going to address Mr. Sigmund's position regarding Dr. Muffalato, and Cayman will address the other ones. They're all our experts. We both filed responses, but we're just going to split it up that way. So I'm just going to briefly address the first one that Mr. Sigmund discussed, which is Dr. Muffalato. We had filed a response, and if you look at the motion to strike, just on its face, the plaintiff's motion to exclude Dr. Muffalato is based on only on reliability, asserting that his opinions are unreliable because he hasn't treated or examined the plaintiff personally. That's not a requirement under the rules and under the physical examination rule of 204.3. That may be more an argument to the court, but it still says in the rule you can't use the exam or the failure to seek an exam as some evidence related to the expert's opinions. And then just very briefly, Your Honor, the last page of his report says, my opinions are based on my education, training, and background as a board-certified orthopedic surgeon and fellowship-trained spine surgeon. They are also based on a complete review of all medical records and diagnostic imaging made available to me. A reasonable degree of medical probability was utilized to arrive at these conclusions. And so, he's qualified. The plaintiff didn't even make an argument regarding his qualifications. There's no issue regarding the reliability of opinions based on his failure to examine. And Dr. Muffalato is actually a certified spine surgeon, and so could perform the surgery that the plaintiff's attorney or expert or is qualified to opine on the reasonableness of a surgical intervention as set forth by the plaintiff's expert. Thank you.
Okay.
Yes, Your Honor. Sorry to interrupt.
Go ahead.
I'll continue with Dr. John McElroy. I'll address that first. First of all, as plaintiff counsel mentioned, no depositions have occurred for Dr. John McElroy, Dr. Braga, or for Dr. Evans. Dr. Evans' deposition is scheduled for later today. In terms of Dr. McElroy, he's a board-certified orthopedic surgeon with a fellowship training in spine surgery. He had an extensive review of Mr. Chi plaintiff's medical records, including CT scans, MRIs, X-rays from multiple dates to ground his opinion in concrete evidence, not speculation. Plaintiff's main argument that Dr. McElroy's opinion differs from the other expert, Dr. Muffalato. It's at the end of the day, Dr. McElroy is an expert with his own opinion, and they can come to a different conclusion. Plaintiff counsel has not addressed any issues with his methodology. He is simply pointing out a difference in opinion. And that should be up to the jury to decide, not in terms of any violation with the Robinson factors. Dr. McElroy addresses the issue of whether or not plaintiff's injuries will need future care from this alleged accident. But his opinion is based on records, and there's no issue that seems to be brought up by plaintiff counsel in terms of his methodology. Now, if the court would allow, the defendant would like to present Dr. Evans to be sworn in and give testimony briefly today, if the court would allow.
All right. Well, y'all announced for 30 minutes and you are beyond that. So, I mean, we also have another hearing that is patiently waiting, and they probably announced accurately for the amount of time they needed. So I think we need to move it along.
Of course, Your Honor. I'll be brief. Just in terms of, I'll just argue for Dr. Evans. Dr. Evans went through plaintiff's records, and his main conclusion that he is unable to come to the determination of whether or not plaintiff sustained a traumatic brain injury from this accident. It's as a result from plaintiff's records, which are his subjective opinion of what he tells his doctors, which leads Dr. Evans to come to an inconsistent opinion. Plaintiff's argument that Dr. Evans therefore should not be reliable because of that It has nothing to do with his methodology as an expert. It has only to do with what the records that have been presented to Dr. Evans. There's no direct issue with that. And in terms of Dr. Braga, who's a neuropsychologist, he's a clinical psychologist with extensive experience. Now, with plaintiff's main argument that she uses the definition of medical certainty rather than based on a psychology degree of certainty, her opinion can be better clarified through cross-examination and through deposition, which has not occurred in this case. I think a deposition would be necessary in order for plaintiff counsel to draw that out, which has not occurred. And in terms of brevity and because of our short time, I will conclude.
Okay. So you concede that Ms. Braga can't give an opinion based on reasonable medical certainty?
Yes, Your Honor. She's not technically a medical doctor. We are aware.
Okay. And at the time of trial, are you willing to stipulate that she's not going to be giving any opinions based on reasonable medical certainty since that's outside of her purview?
Yes, Your Honor. We are aware of that. Her main view is within psychology, not necessarily in a medical field.
Okay. All right. All right, Mr. Sigmund, anything else on these experts?
Nothing further, Your Honor.
Okay. All right. Well, as to Mopoletto, McElroy, and Evans, I am going to deny the motions to strike. I think it's been made clear by the stipulation on the record that Maria Braga is not going to be testifying based on medical probability or any other standard that she is unqualified to render. So I don't think she should be permitted to give testimony based on reasonable medical certainty if she's not a medical doctor. So I'm not sure you really need a ruling on that one way or the other. I think she's an expert, but not going to be testifying based on reasonable medical probability. Does that make sense?
Yes, Your Honor.
Okay. Do you need anything further from the court, or have we covered all of the pending motions?
I just have one clarifying question. So with regard to Ms. Braga, is the motion granted or denied?
It's denied.
So plaintiff's motion is denied.
Yes.
Okay.
Your Honor, just for the record, to be clear, Dr. Braga will supplement her report as well.
Okay. Well, whatever trial judge you are assigned to will be able to address these issues, but I think it's fair to say that someone who's not a medical doctor can't be giving opinions based on reasonable medical probability. So whether that's an error in her report that needs to be addressed or something else, I'm sure that y'all can get it figured out before your trial setting.
Thank you, Your Honor.
Thank you,
Okay.
Judge.
Y'all are free to go. Thank you.
Thank you.
So we are here on 4400 Sam Bass Road versus Patriot et al. So we've got a couple of different motions. Let me know which you want to take up first.
I'm fine with the motion for continuance going first. They're both unopposed, Your Honor.
Okay, well, there have been some changes in Texas law recently on continuances, and we are required to report every trial continuance that is granted to OCA, including the name of every attorney who a motion is granted for. So just because it's unopposed does not mean it is going to be granted. On the other hand, if you had an agreement to reset a trial date, that could be done without coming to court. That could be done by submitting an agreed order to reset the trial. This is a 2-year-old case. I've read the motion for continuance. So let's just pause here and talk about whether If nobody wants to go to trial, that is fine. You can come to an agreement to reset it, but I'm not simply going to rubber stamp something that's, quote, unopposed on a 2-year-old case that should have been brought to trial by now. So I don't know if y'all want a breakout room so you can talk about your options. Happy to provide that if it's something that might be helpful.
That's fine with me, Your Honor.
Okay.
Judge, before we do that, is there any way we could just have my motion on the motion to substitute heard? We've had this on file for quite some time, and I'm a little strapped in what I can do because I'm not officially in the case.
Okay.
And
Okay.
And our motion was originally set. Patriot just piggybacked on our motion today. So I'd just really like to get an order on our motion to substitute if I could.
Okay. Is everybody else okay with that? All right. And so you are here, you're coming in, and you're ready to proceed on the other motion, but you need to be brought in first.
Yes, Your Honor.
Okay. All right. It sounds like the court can grant the motion to substitute counsel then, Ms. Fortenberry.
Thank you, Judge.
And so let me just say, I'll have Ms. Seeger send you all an invite to a breakout room where you can confer. And if indeed there is an agreement to reset the case, then there would be no need for a continuance to be granted or heard, and no need for this court to report the granting of a continuance to OCA. Make sense?
Your Honor, thank you.
Okay, fair enough. We'll wait here in the virtual courtroom until y'all have had an opportunity to talk that over. So accept the invite to the breakout room when you get it. Thank you.
Thank you.
Right, it looks like we have everybody back from the breakout room.
Your Honor, everyone's agreed. We're gonna submit an agreed amended DCF.
Okay, and since you've appeared here in the 200th today, you're welcome to send that to Ms. Seeger and I can get it signed for you. With reference to a new trial date, if you could, you'll need to let court admin, give them a call, let them know the new date you picked. And just a reminder, a judge signing a DCO doesn't actually get it set. You have to get someone at court admin to get you on the calendar. So.
And Ms. Seeger's email is that?
She provided the Zoom link, so someone in your office has it.
Thank you, Your Honor.
Okay, well, I'll make a note that you agreed to reset this matter so that a continuance hearing was not necessary.
Perfect.
Thank you. First up, we have Key versus Kunchari.
Yes, Your Honor. Ali Akhtar is here for the defendant, Suganda Kunchari. We announced for 30 minutes total. I believe it can still be done in that time. And yes, we're requesting a record. This is a summary judgment motion.
Good afternoon, Judge. Troy Boland appearing on behalf of the plaintiff, Joshua Key. And yes, I believe a record is necessary.
Right. Normally, we don't give records on summary judgment hearings. Do y'all have extensive objections to argue, or?
I
guess
actually, we could proceed with that one, I suppose.
Okay. Well, normally they aren't taken, so I guess I'm wondering what the reason for the request would be.
I'll agree with defense counsel that we don't need a record, Judge.
Okay. All right. Fair enough. Thank you. And next up, we have KM versus Menlo Mueller Austin Apartments et al.
Rhiannon Judge, you here, Your Honor, on behalf of Clear Property Management, LLC. I believe we won't need more than 10 minutes and we do not need a record.
Good afternoon, Your Honor. This is Anna Greenberg here for the plaintiff. This is an unopposed motion, so I don't really see that we'll need much of any time.
Okay. Anybody else here on that matter, or just the two of you?
Your Honor, I heard from the other two co-defense counsels earlier today, well, yesterday and then earlier today, and they said they would not be attending.
Okay, fair enough. All right, thank you, counsel. And then we had a couple of hearings that I think have passed, and next will take us to Warner versus Hess.
Yes, Mark O'Donnell here for the plaintiff, Clifford Werner. I can't imagine will take longer than 10 minutes, and I don't believe a record is needed.
Andrew Barron for defendants Hess. I don't think a record is needed, Your Honor.
Okay, you agree with the time announcement?
Yes, I do, Your Honor.
Okay, fair enough. All right, why don't we take care of the motion for leave first, because I think it's going to be very short on KM versus Menlo.
Yes, Your Honor.
Thank you, Your Honor. Your Honor, this is an unopposed motion to designate Octavio Contreras Guzman as a responsible third party in this matter. Mr. Guzman was named as plaintiff in her live pleadings as the person who broke into her apartment and assaulted her in this matter. Defendant timely listed Mr. Guzman as a potential responsible third party in their initial disclosures, and this case does not currently have a trial date. Such defendant's motion is timely. I would also like to point out that this motion has been on file for the requisite, I believe it's 15 days, and no opposition motion has been filed.
Okay, Ms. Greenberg.
Plaintiff has no objection to the designation as a responsible third party of this perpetrator.
Okay. And let's see, this case has been on file for a while. You have you do have a jury trial date for next year. Is that correct?
Oh, yes, Your Honor. Apologies, Your Honor. It must have been assigned after we filed.
Okay, it looks like it has a May 2026 date. And a case this old, if it didn't have a date, I would be telling you, you need to get a date. But it looks like that has been accomplished. Counsel, I'm going to grant the motion for leave. Do you have an order that's agreed as to form that you can submit for my signature?
I do not believe I have one that is agreed as to form. There is an order on file. Would you like me to submit it to all parties and get one agreed to this form?
Yes, if you would circulate it, that way Ms. Greenberg can review it, and then it can be emailed to Ms. Seeger. She provided the Zoom link, so that will get it to me quickly.
I will take care of that. Thank you, Your Honor.
Y'all are excused from the virtual courtroom.
Thank you, Your Honor.
Thank you. All right, and now we're going to go back to the top of the docket, which is our summary judgment on Key versus Conchari. So if you're here on another hearing and want to turn off your video until I call you back, we're going to take this up next. Okay. All right. So Mr. Akhtar, it's your motion.
All right, thank you very much, Your Honor. I represent Ms. Suganda Conchari, the defendant, who's the party moving for summary judgment today. The plaintiff, Joshua Key, filed this case in the fall of 2017. Yes, it bears repeating that we are approaching the 8-year mark that this case has been on the court's docket. For all that time, the plaintiff's case and claim has been this: that he and his then girlfriend, Jamie Lobach, allegedly loaned my client $65,000, that the parties executed a purported promissory note for repayment terms, that my client allegedly defaulted and never paid back on this purported loan, and the plaintiff has been suing for some god-awful number of $170,000 for principal, accrued interest, attorney's fees, etc. My client, Ms. Conchari, is moving for summary judgment today on 2 grounds. The first one is a no evidence MSJ, based on the fact that over an almost 8-year period of discovery, there has been no evidence produced by the plaintiff of any alleged loan whatsoever, either $65,000 or otherwise. They've not produced one shred of evidence in the form of a canceled check, a bank account statement, no electronic ACH, no wire transfer, absolutely nothing. So therefore, the promissory note is illusory and there was no consideration ever given for it. There's also a traditional motion for summary judgment that we file based on the fact that even if Your Honor found that there was some fact issue on that, perhaps some evidence of consideration, the promissory note itself is illegal and unenforceable under the Texas Finance Code because it states plainly a usurious interest rate of 20%. And that's a per se black letter law statutory violation for which there is no defense, as much as plaintiff's counsel will try to come up with one. So the MSJ on the traditional not only seeks dismissal of the plaintiff's case, it also seeks my client's statutory damages and attorney's fees for usury. So to quickly set the stage for this motion, here are all the facts that I believe are not in dispute, although plaintiff's counsel can correct me when it's his turn. My client, Ms. Conchari, is Thai. That's her native language. Her spoken English is very poor, and her ability to read or write English is even worse than that. I don't think even plaintiff's counsel will dispute that. In fact, we talked about having to hire an interpreter if this were to go to any oral testimony like deposition or trial. So the plaintiff, Joshua Key, is the one who drafted and produced all these documents and is responsible for choosing all the language and all the terms in them, not my client. She couldn't draft anything like this even if she wanted to. It's also undisputed that my client and a couple of other folks were all co-owners of a Thai restaurant, the Chang Thai restaurant, on North I-35. and that in the 2015 to 2016 time period, the plaintiff, Joshua Key, came along and decided that he wanted to buy into this business. The plaintiff drafted up a bill of sale document in which he purchased a majority ownership interest, 51%, for the sum of $20,000 and desired to become the managing owner of this restaurant. It didn't go well. The restaurant was not doing well, it was losing money, and within even less than a year, the plaintiff wanted out. But what he did then is bizarre. As part of a big tantrum, he drafted up this promissory note, which was dated December 30th, 2016, which purported to say that he and his then girlfriend, Jamie Lobach, who was formerly a co-plaintiff in this case, but has not been a plaintiff in this case since September of 2023, had personally loaned my client $65,000 and had set forth terms for repayment, including illegal interest terms that we'll get into later. My client, lacking the English reading skills, went ahead and signed this. It's undisputed that Jamie Lobach was never an owner of this business, was never a part owner of this LLC, was never on any bill of sale document. She was Mr. Key's girlfriend at the time, and like I said, she was a former co-plaintiff in this case, but is no longer one. 2 years ago, she non-suited herself and her claims entirely from this case, and that non-suit was filed by this very plaintiff's counsel who's here today. So that leaves only this plaintiff, Joshua Key. So that's it in a nutshell. Ever since then, and for the almost 8 years that this case has been on the docket, that's what plaintiff Joshua Key has been claiming, that my client defaulted on a promissory note for an alleged $65,000 loan. So I will start by sharing my screen really quickly and asking the court to take judicial notice of the plaintiff's own motion for summary judgment, which he filed in March of this year, March of 2025. I didn't submit it as an exhibit because I didn't feel the need to. It's already part of the court's pleadings record. But this, which I'm circling right here, is the plaintiff himself summing up the nature of his suit, which has been on file for almost 8 years. He claims that he, Key, loaned Conchari $65,000 to pay off debts of a restaurant. The loan was reduced in writing to a promissory note. She defaulted, and therefore he's suing for breach of contract, his principal, his interest, and all his attorney's fees. So it's right there in plain English. That's been the entirety of his case and the whole alleged basis of this lawsuit for almost 8 years. I will also put up what I have submitted as an exhibit, which is Defendant's Exhibit 1 submitted with the motion. It's part of the exhibit record and it's been exchanged between the parties. This is an affidavit that the plaintiff, Joshua Key, drafted and signed under oath back in January of 2025, and that's what he attached to his March 2025 motion for summary judgment. As you see here again, under oath he states, starting with paragraph 3, the restaurant was in severe financial distress. Conchari approached me for financial assistance. I agreed to do this and I loaned Conchari $65,000. Okay, he says it. In order to memorialize that loan, Conchari and I executed a promissory note on or about December 30th, 2016 for the principal amount of $65,000. He doesn't make any bones about the fact that he stated a 20% annual interest rate in that promissory note. So it's all there in his own affidavit. Okay. Let me go ahead and put up what I've also marked as Defendant's Exhibit 2. This is the actual promissory note itself. And again, this has already been exchanged between the parties. It's been part of previous motions and all of that. So the promissory note, again, dated December 30th, 2016 for $65,000. And as I stated before, the borrower is purported to be my client, Suganda Conchari. The lender is Joshua Key and Jamie Lobach, collectively the lender. That's his former girlfriend who's no longer in the case. It states clearly that this balance shall accrue interest at a rate of 20% per annum until paid on the unpaid balance. It has a bunch of other things which we'll get into later, which aren't important for right now, but I'm just showing the court that this was a clearly executed document dated December 30th, 2016 and notarized, and it was prepared entirely by the plaintiff, Mr. Joshua Key, because my client would have been incapable of drafting a document like this. Okay. Now, it's important to note that the plaintiff set his motion for summary judgment back in May, but then he pulled it down and he has not pursued summary judgment ever since. I think as we go through the rest of this hearing, it's going to become pretty clear why. I will also ask the court to take judicial notice of the defendant's answer, which she filed all the way back at the very beginning of this case, December 2017, as I'm circling here. And from the beginning, she has made clear, long before I got involved and back when she had previous counsel, that A, verified denial. This is an answer under oath. This is not just a simply general denial, but that there was no consideration. There was no such value received. There was no $65,000. And second of all, the contract is usurious. Those have been part of her verified denials in her answer under oath since the very beginning of this case. And that's important because, as set forth in our no evidence MSJ for today, Over 7.5 years of discovery, not once has the plaintiff been able to produce a single shred of evidence for the $65,000 that he's claiming that he loaned to her. Again, no check, no ETF, no ACH, no wire, no absolutely nothing. So that's why we're moving for the no evidence MSJ as to the alleged $65,000 loan. There's no evidence that it existed. It's a phantom figure which has been made up by the plaintiff, and he got my client to sign a promissory note for money that was absolutely never given to her. Plaintiff can't show it ever existed. Now, I thought I was going to have to go through all the discovery that I attached to our MSJ and show why absolutely none of it matches up to this allegation of $65,000, but now I don't have to do that. And the reason why is because the plaintiff has basically conceded all that in the response that he filed to our motion for summary judgment. So in the response he filed just in time for today's hearing, I'm going to put up as defendants 3 a new affidavit which Mr. Joshua Key, the plaintiff, has executed for the first time in July of 2025, after more than 7.5, almost 8 years of discovery, radically retelling the story and radically recharacterizing this $65,000. Let's take a look. He says down here, in March of 2016, Sugandha, along with her then business partner Prayum Tanpun, made representations to me about the restaurant. I believed her representations were true. She coaxed me into signing my name as 100% owner of the restaurant. We're going to go through all the documents that show that this is a ridiculous, perjurious document. But the important part is, now look how he recharacterizes the $65,000. He says, in early May 2016, the landlord for the restaurant told me that Sugandha was over a year behind in rent to the tune of $65,000. Okay, first of all, this is completely new testimony that he's trying to introduce way outside the discovery period. The discovery period has been closed for maybe 5 years now. And it's brand new hearsay testimony that he's trying to introduce that he claims a landlord told him. This has never been adduced in discovery. This is a completely new allegation that he's come up with for the first time, just kind of in a shameless and dishonest attempt to try to avoid this summary judgment. He, where do we go here? Okay. In late November 2016, Sugandha called me and asked to, quote, buy the restaurant back, which I agreed to do so in exchange for $65,000, which represents the restaurant's market price suggested by my real estate agent, Hong Lee. Again, first of all, complete hearsay testimony to bring in a guy for the first time named Hong Lee to come up with the argument that now the $65,000 constitutes the market value of selling back the restaurant share to her. And third, way outside the discovery period. Frankly, Your Honor, this, if you try to put these two affidavits side by side next to each other, they can't both be true. One of them has to be perjury. One of them has to be a false statement under oath. They are absolutely both completely inconsistent with each other. He then says he believes that $65,000 was, quote, repayment of my time and energy spent trying to save the restaurant. I'm sorry, Your Honor. If you purchase a 51% controlling interest in a business and the business doesn't make money, you don't get a big fat consolation prize. It's axiomatic. When you own a business, if the business makes money, you make money. If the business doesn't make money, you don't make money. And that's all there is to it. Okay. By signing the promissory note, Sugandha promised to pay back what she cost me in monetary terms, such as distraction and opportunity costs and stress that she put me under. Again, an absurd recharacterization of this $65,000, which is totally different than what he's been saying for over 7.5 years in this lawsuit. Okay, I'll try to move this along. Okay, so he's grasping at straws. What he's basically saying is, oh, no. When I first drafted my petitions back in 2017 and amended them in 2018, when I responded to discovery, when I drafted my own motion for summary judgment back in early 2025, and even when I executed an affidavit in January of 2025, and when I repeatedly said I had loaned her $65,000, no. Don't believe that. That's not what I meant. What I really meant to say, also under oath, is that that $65,000 is just what I believed was the opportunity costs of what I lost out on by having to take over this flailing business. And she agreed that this is what me reacquiring the business was worth. Again, absurd. This is a shameless about face. But I'm sorry, there's actually one part where I forgot to read. Yes, right here. The very last part of this paragraph. He now says that that promissory note was, quote, in effect, a bill of sale and is evidence of the transfer of the legal ownership of C.H. Thai back to her. That is really, really interesting, Your Honor, because I would like to next put up what's marked as Defendants 4, which is an actual bill of sale. And I would like to show you that that was signed on the exact same date of the promissory note that we were just talking about, December 30th, 2016. Again, all of these documents were prepared by the plaintiff, Joshua Key, not my client. So why are we talking about what is in effect a bill of sale when we have an actual bill of sale in which this, Joshua Key, the plaintiff, is the one purporting to purchase for $20,000 the 51% majority controlling interest and to have executive control of the restaurant? That's the document that he prepared. That's what he had her sign. He got unhappy with how unprofitable the restaurant was, but he doesn't get to turn around and draft up a completely phantom fictitious promissory note that she has to pay him back $65,000 at the rate of 20% interest per annum. So when he's trying to say, oh, well, in effect, that promissory note was a bill of sale. No, there was an actual bill of sale and it was going in reverse, him paying her, and it was signed on exactly the same date. So I'm sorry, he's tripped over his own tie when he's making this argument. I'm saying that about the plaintiff. I'm not saying that about plaintiff's counsel, who I'm getting along with just fine. But okay, this claim has this $20,000 bill of sale has actually never been what plaintiff's claim is based on. His claim has always been based on the $65,000 alleged promissory note, alleged loan, and all the interest and attorney's fees that accrues on the default. So, Your Honor, I just want to say, I think it's patently clear he's gaming the system. He's gaming this court. He's just harassing my client for almost 8 years now with this lawsuit. And he's produced not one single shred of evidence to substantiate the alleged $65,000 loan. This July 2025 affidavit, it's a very bad faith attempt now at the last second to try to retell his story. It's flat out perjurious when it puts next to his other affidavit and his discovery responses and his prior pleadings and his prior motion for summary judgment. And it's also a bad faith attempt to try to introduce a bunch of new hearsay evidence and testimony, which is way outside any discovery period. He's just trying to prolong everyone's agony here. So I'm beseeching the court to put a stop to this and dismiss the plaintiff's claim based, first of all, on a no evidence MSJ. Now, to try to move this along, more importantly, even if Your Honor would find that there's some minuscule fact issue which the plaintiff has raised with this affidavit, and that he may have some scintilla of evidence to support this alleged loan or consideration of $65,000, it still doesn't matter. The second and more important part of our MSJ is the traditional MSJ based on statutory usury, and that's under the black letter law of the Texas Finance Code. So we've showed the court the promissory note, which clearly states the 20% annual interest rate on the unpaid balance. We've showed you his own motion for summary judgment, which restated it. We've even shown you his own January 2025 affidavit, where he proudly stated it under oath that she owes 20% annual interest on the unpaid balance. That's illegal and that's open and shut. This is not submitted as an exhibit, but I'm just putting it up for judicial notice. The Texas Finance Code, Chapter 302, states clearly that the maximum amount of interest is 10% a year, except as otherwise provided by law. There is no other legal exception to this. Again, plaintiff's counsel is going to try to put up an argument for it, but I can show why all of those arguments fail. If it is for more than 10%, it's usurious, it's therefore void as contrary to public policy, and it gets subject to the penalties prescribed in Chapter 305, and I can show you what those are. Chapter 305 clearly says, and I've done the calculations in our motion, so I can actually, the calculations show up when I'll show you the ending part of our motion for summary judgment and how much damages that the plaintiff actually has to pay my client for this, plus attorney's fees, which are authorized down here at the end of the Texas Finance Code statute. Okay. So the defendant has consistently also made this part of her verified answer and denials. I showed you her answer that was filed back in December of 2017, where one of her verified denials was clearly that the contract sued upon is usurious. So the plaintiff makes two arguments for why they should avoid penalties and why they should still be allowed to pursue their case. He makes the argument in his response that, first of all, oh, this is a commercial loan or note, so the 10% doesn't apply. Really? Well, I'm going to go ahead and put back up that promissory note. And I'm going to challenge the plaintiff's counsel at any point in his response to show me where in the four corners of this document, drafted entirely by the plaintiff, it says anything about this being a commercial loan or commercial note or for any business purpose, any business equipment, any business property, any business ownership interest, or any business whatsoever. It doesn't. You won't find it in a single page on this document. It's structured or purported to be a personal loan between plaintiff and his then girlfriend, Jamie Lobach, to my client in the amount of $65,000. So first of all, if it was a commercial note, then why is Jamie Lobach in this? She was never a part owner of the LLC. She was never a business owner. She was never involved in the restaurant. She was never a part owner of the LLC. Second of all, if it was a commercial loan or note, then why would the alleged borrower be my client and not the LLC or the restaurant business or company itself? Third of all, he actually got her to sign something which put a security interest on her house as security for this alleged $65,000 loan. What does her home have to do with the restaurant business? Again, if he's trying to claim this is a commercial loan or note, it's belied by absolutely everything that's in this document. So there's not a single thing in this document pointing to this being commercial loan or somehow exempt from the 10% statutory maximum. And further, as I've already shown the court, the parties had already executed a separate bill of sale for an entirely different amount and different purpose on that very same date, December 30th, 2016. So that shows to me that the plaintiff was very capable of drafting all these documents in such a way as to include what he wanted to include, to leave out what he wanted to leave out, and to show what was for business or commercial purposes and what was not. In this promissory note, he included absolutely nothing about any business or commercial purpose. Second of all, plaintiff's counsel argues in his response that, oh, well, the promissory note has a severability clause, so if the interest rate is illegal, we can just sever that and we can ignore that and we can continue on with the rest. Okay, that's a very creative and novel argument, but it has no basis whatsoever in the statute, and it doesn't provide any defense whatsoever against the usury statute. Again, I could put them back up on the screen. The Texas Finance Code Chapter 302 and 305 are written with admirable clarity. There is no reformation clause in there whatsoever. There's no retroactive provision. There's nothing in there that authorizes the court to go back and say, well, we could go ahead and enforce this contract as if it had a legal interest rate to begin with. We can ignore the usurious interest. Nope. It's written very clearly that a usurious contract is against public policy and void. The Texas legislature wrote and passed this statute for a very clear reason, and the reason is this: to punish people like the plaintiff who draft up and get other people to sign usurious contracts. So, lastly, what are the damages that would be due and owing to my client on the statutory usury counterclaim? I've included that towards the end of our motion, and I'll just try to get to that part real quick. Okay. The statute is very clear. She has her option of the greater figure under the statute, which is you compute the amount of interest that would be allowed by law, which in this case is 10% times $65,000, which is $6,500. You subtract that from the total amount of interest which was contracted for, which is 20%, which is $13,000. So that yields $6,500, and then you treble that number, treble damages, $19,500. There's no discretion under the statute. That's what the plaintiff now has to pay my client, in addition to the contract being void as against public policy. In addition, they also have to pay my client's attorney's fees. And I've already submitted my affidavit and all of my itemized billing statements with the motion. I'll just point out that since the filing of the motion, there's been some additional time accrued for reviewing the plaintiff's response and for prepping for today's hearing, and then, of course, for the time spent in today's hearing. So all the time that has been spent, all the attorney's fees, and I have billed my client at the very reasonable and necessary rate of $300 an hour, which is less than what I would normally bill to clients based on my now 25 years of experience as a practicing attorney in the state of Texas. But $4,590 is the amount of fees accrued up to, but not including today's hearing. I'm going to assume that we're probably going to spend about 45 minutes to an hour. I know I announced for half an hour, but I'm not sure if that will end up being stuck to. But if it were to be about one more hour, it would be another $300, making the total $4,890 that should be paid back to my client, again, under the usury statute. So, quite simply, A, no evidence whatsoever of a loan. The only thing he can do now is come up with a bad faith attempt to try and say, oh, no, I never meant to say it was a loan for the past 7.5 years. Now I'm going to say it was something else. B, even if you believe that he has produced some scintilla of evidence of $65,000 consideration, this is statutory usury. His contract is void, it's over, and he has to pay my client damages. That's why we're seeking summary judgment. Thank you.
All right. Mr. Bolin.
There we go. Can you hear me?
I can.
Good afternoon, Judge. I'll start out by saying that neither party in this lawsuit could be characterized as a sophisticated business person. My client's clever drafting and trying to pull a fast one in the documents he drafted all came from Rocket Lawyer, which, as everybody knows, is rarely a good idea for anything. When my client became owner of the restaurant, he was told that the restaurant was in great financial health, it was profitable, and that Ollie's client needed assistance managing the restaurant. And so my client agreed, and shortly after joining the restaurant, he started to find out that instead of being profitable, it actually had a lot of debt. It owed the IRS, it owed back rent. There's an exhibit to defendant's MSJ. It's a letter from the landlord saying that she was behind $19,000. It turned out to be even more. She also owed the IRS, which is attached to our motion as Exhibit D. And she also owed the Texas Comptroller. My client should have come up, well, there's a lot of shoulda, coulda, wouldas, but he should have come up with something different than calling it a promissory note. After he bought the restaurant and realized that it was in terrible financial shape, Miss Country approached him in November 2016 and offered to buy the restaurant back because she believed that she could sell the hard assets of the restaurant and, make some money back. So my client sold the restaurant back to her, and she did not have the funds to pay for it. So he agreed to accept a promissory note in order to sell it back to her. And on that same day, they changed ownership of the restaurant. They took him out of the LLC and put Miss Country down as the 100% owner. And about 2 weeks later, she did in fact sell the assets of the restaurant, but didn't pay Mr. Key anything for it. They haven't spoken since then. And so the loan, Your Honor, yes, it is a loan. It was a loan for the buyback of the restaurant. And proof of the $65,000, defense counsel's correct. There is not a deposit slip that says $65,000 from my bank to defendant's bank. Instead, it was, for instance, in defendant's motion for summary judgment, he references a loan that the restaurant took out for $33,100.28. My client paid that debt down to $9,792.85. Defense also recognizes that my client sent a wire transfer to Miss Country's ex-business partner, who we haven't been able to locate, and we have reason to believe he went back to Thailand. But there's evidence of a wire transfer for $7,700. And then lastly, there's a payment to the comptroller for $2,292.89. And that's also in defendant's motion for summary judgment. So there are even more payments, such as my client paying for rent, trying to get caught up. We have tried to get those records, and because my client wasn't listed on the lease, they didn't modify the lease at all. Another example of their unsophistication. So when he tried to negotiate with the landlord said, "Hey, I've been instructed not to speak with you." And I think that's also on defense counsel's MSJ. If not, it's on mine. So what we have is, let me see, $33,300 of just 3 items that evidence payments that my guy made to lower down the debts of the restaurant. My guy ran out of money. He ran out of credit. And so when Miss Country offered to buy it back, he was more than willing and said, "Okay, well, I'd love to have some of my money back." And that's when they agreed to the $65,000 promissory note. The reason it was characterized as a loan instead of owner financing was an effort to use the KISS principle and just keep things as simple as possible. There's a promissory note. Parties entered into it voluntarily. Payments were supposed to be made. They were not made, so the amounts due. That was the intent at the beginning, was to keep it simple and not all of this other stuff that's going on in the background. But now all of that stuff has got to come out. And so that's why it's not new information, but we're just adding to what actually happened that will have to be determined at trial. So what defendant's argument that there's not a scintilla of this, where the $65,000 came from, there's actually quite a bit of evidence of where it came from. We have 33,000 of it just in these motions. And the rest of it could be discovered hopefully through rent payments and other expenses that we did ask for in discovery. And this was with her, it was either second or third attorney. It wasn't this counsel at all. And we asked, for them to supplement, and no response. So there is more than a scintilla. And so we would argue that my client did perform his part under the contract of the $65,000, and that at minimum there exists fact issues that need to go in front of a jury. The usury claim, I uploaded Texas Finance Code 306, and I'm not savvy enough to pull it up on screen. I'd have to ask my kiddo in college, but Section 306 says a commercial loan is a loan made primarily for business, commercial, investment, agricultural, or a similar purpose. Well, this was an owner financing for a business person to buy a business from a business person. And so I would argue that that is a business purpose. And 306.002A says that a creditor may contract and charge and receive from an obligor on a commercial loan a rate that does not exceed the applicable ceilings of Chapter 303. And so if you take a look at 303, it says that a contract made under which credit is extended for business purposes, commercial, investment, or a similar purpose, the ceiling is 28% per year. And so the 20%, I would argue, is legal and authorized under the Texas Finance Code because it's a commercial loan. It's for a business purpose. And so 20% would be entirely proper. And the severability clause, which frankly, I rarely see in a promissory note. I think this is another Bob Shapiro rocket lawyer clause that was just kind of slapped in there, but it says what it says, and it says if any provision is unenforceable, then the remaining provisions stay in effect. And so I guess the worst case scenario is you say, well, Troy, the 20% is unenforceable, it's usurious, and so it is to be struck. And then I guess it would come down to an argument, well, then is it at 0% interest or a statutory default like 10%? So Judge, that's kind of the crux and the short version of our story is that there is evidence of performance under the contract, that the loan should have been called an owner financing deal for the buyback. There's proof of the money paid that to show where the $65,000 came from. And so my argument is that he did perform under the contract, and defense counsel's motion for summary judgment on that issue should be denied. And same for the usury claim. Under the finance code, it's a commercial loan. They can charge up to 28%. He charged less than that. So defendants MSJ on that issue should also be denied. And that sums it up, Judge.
Okay. All right, Mr. Akhtar, you have the final word if there is anything else to be added.
Sure. I'll just try to make 3 or 4 very quick rebuttal points. So again, just to kind of demonstrate the absurdity of this case lingering and lingering, after almost 8 years of being on the docket, plaintiff's counsel is saying that they're still trying to discover evidence. They're trying to discover evidence about rent or discover. How long is this going to go on? Second of all, so that's why no evidence MSJ is appropriate, because how long can a discovery period possibly be kept open before we finally say enough is enough? There's been no evidence produced. MSJ. Okay, second point. He says it should have been written a different way. Well, this case isn't about could have, should have, would have. The plaintiff was more than capable of drafting a document which he entitled a bill of sale in which he purchased a 51% interest in the business. Stands to reason he was perfectly capable of drafting up a reverse bill of sale in which he said, I'm selling this 51% interest back to you for $65,000 plus interest. He certainly could have done that. He did not. He decided to structure it as a personal loan between himself and, again, I can't emphasize this enough, his then girlfriend, Jamie Lobach, who had nothing to do with the business and who is no longer even a plaintiff in this case. So it's quite obvious that it was not a loan for commercial or business purposes. Everything about that promissory note looks like a personal loan, personal $65,000 allegedly made from Joshua Key and Jamie Lobach to Suganda Kunchari for $65,000 at 20% interest, secured by a security interest in her home, of all shameless things. That's what he got her to sign. It's incredible. Lastly, he talks about just being able to sever the usurious interest. Well, again, a severability clause in the contract cannot trump a statute. The statute says what it says. The legislature says once you have a usurious contract, it's void as against public policy and the defendant has to pay the plaintiff damages. Open and shut, per se black letter law. So those are my points, and that's why we're arguing for the summary judgment.
Okay. All right. Thank you, counsel. I'm going to take a look at what is in the summary judgment record. Let me ask Mr. Boland, I noticed the response doesn't look like it was timely filed. I wonder, was there an extension given on that, or can you
Yes,
like
we agreed to allow a couple of extra days. I think plaintiff's counsel was on a trip.
There was, Judge. And thank you again, Ollie, for the professional courtesy on that.
Sure.
Okay. Great. So I will consider the motion and the response, and we'll get you an answer. It may be a week or two before you hear back. Okay.
Sounds good.
Y'all are free to go. Thank you for your time here this afternoon. Have a good
Thank
day.
you, Judge. Have a good afternoon.
Thank you, Your Honor.
Take care. Warner versus Hess. Okay, that's going to take us.
Yes. Good afternoon.
Thank you for being patient.
No problem.
Okay, so somebody doesn't want to go to mediation, I think.
Not necessarily, Judge. I represent the plaintiff. We have tried to mediate this case multiple times. Back in March, we attempted to mediate. I was sitting in a conference room with my client, and then 45 minutes before the mediation, the defense counsel notified us they could not go forward. I did not ask why. I assumed it was for good cause, and don't cast any aspersions on opposing counsel in that respect. We then rescheduled mediation for May, and in the days leading up to that mediation, staff for the defendant said that they were no longer able to go forward with mediation on that day. And since the end of May, we have had a number of different email conversations attempting to schedule mediation, but still have not got them to agree on a date. So given that the deadline to mediate the case in advance of trial, which is scheduled the week of August 18th next month, was July 3rd, I wanted to have this motion on the record so that the lack of mediation would not prevent us from going ahead with trial next month if necessary.
Understood. Thank you. All right, Ms. Barron.
Yes, Your Honor. We also are not opposed to holding a mediation. That being said, if mediation is waived at this point, we don't see that as being a reason to forestall trial. I understand that the plaintiff is elderly. We don't want to push this out unnecessarily if we have to, but I do believe that mediation in this regard would be beneficial to trying to resolve the matter prior to trial. The initial cancellation was due to a family issue that I had. It was an emergency. The second cancellation was due to the claims representatives being unavailable, and we've been unable to schedule since. I was out of the country for the first 2 weeks of June and was not able to schedule it anytime prior to July 3rd deadline.
Okay, so let me back up. Was there a mediator that you agreed to use, Mr. Rubin?
Yes.
Yes.
Okay. And so I understand the plaintiff's position. They've tried, and through no fault of their own, 2 mediations have been canceled. So I think they're kind of done with it. But I understand that a mediation could be helpful. Was Mr. Rubin offering mediation by Zoom or remote?
Yeah, everything would have been done by Zoom. It's just been a matter of the fact that we've not been able to get usable dates or dates that comply. I believe our last correspondence, the defendants were supposed to give us some more dates that they were available with Mr. Rubin. I mean, I'm still open to having a mediation at some point before trial. I just don't want my lack of mediation, if we're not able to agree a date before August 18th, to prevent us from going to trial next month. And I understand there are all sorts of things outside of our control that could prevent us from having a trial. So that's why I just want to make sure all boxes are ticked.
Okay. And I mean, I guess one thing I could consider is if there was a date Mr. Rubin had available, say within the next couple of weeks, I could order the mediation on a date certain with him. If everybody was available and gonna make it. And I could also impose the cost on defendants to pay for the mediation if there have been costs that have been incurred by 2 cancellations. I don't know what the status of that is.
I believe we've both paid and there's no additional cost if we're able to find a date that works for Mr. Rubin. And to be fair, he's been very accommodating. He's offered 5 o'clock starts for mediations and stuff over the last while. I have not heard anything from anyone at the defendant since June 12th where, you know, they were going to get back to me tomorrow about dates for mediation.
Okay. All right.
We could check with Mr. Rubin and I'll try to get my claims to go after 5 if necessary. Especially if it's court ordered, then I'm sure they'll do it.
Okay. Mr. O'Donnell, would that be something that would be beneficial for your client?
I mean,
possibly.
I don't have. I mean, I want to try and mediate. I'm whether like ordering it by date certain. I don't know what Mr. Rubin's availability is at this point. I don't know what my client's travel plans are. I personally am out of the country from the 28th through the 13th of August. So there's pretty limited time in which we could do a mediation beforehand.
Okay. I could propose something like this. Order the parties to mediate within the next 2 weeks or by July 25th. If Mr. Rubin is available. And if it's not accomplished in that time, then the court will waive the requirement.
That would be fine by me. I hope mediation does work, but I haven't gotten a chance yet.
Right. And I guess I'm a little reluctant to do what I think would be rewarding bad behavior, even though it sounds like one was an emergency, so those certainly happen, but you know, adjusters all of a sudden not being available at the last minute, I would put that under the unacceptable kind of thing, given it's a date everybody agreed to and put on their calendar. So let's try this. I will order the parties to mediate with their agreed upon mediator, Mr. Rubin, by Friday, July 25th. And if that does not happen, then I will waive that requirement of mediation for trial. Okay.
Thank you, Judge.
Does that work? Okay. Mr. O'Donnell, if you want to put together an order that simply states what I've mentioned as far as the court's ruling, circulate that to Ms. Barron, and it can be emailed to Ms. Seeger for my signature.
Okay. Hope to get that over to the court shortly. Thank you for your time.
All right. Thanks, Joe. Have a good day.
See who is here on any particular case, and if they need a hearing still, how long that hearing will be, and whether they need a record. Just so you all know, I have to break at 11:40 today. I do have a lunch. I had a morning hearing that just finished up, so that's why you all were called at 11, because I had an in-person hearing from 9 to 11, and now if anybody needs a contested hearing, you will be coming back after the lunch hour and doing your hearing this afternoon. Just understand that. I think there's some things that don't need a contested hearing that we're going to try and get through, but this is basically an announcement for what's left. All right, Tillman, the Tillman case. Where are we on that case?
Yes, Your Honor. This is Nita Din. I represent Saulette Tillman, the petitioner, and We have everything already agreed and signed in the order. We just need you to sign it. We sent it to you yesterday, late in the afternoon.
My staff was just informing me of that. It looks like it's been agreed to by all parties. And so as long as I sign that, you're passing on the hearing and you don't need a record, correct?
That is correct, Your Honor.
Then that is easy. Is someone here for the other side, or is it just Ms. Den that's here?
I'm representing myself.
And you agree with what Ms. Den said, Mr. Tillman, that it was agreed and I can just sign it?
Yes, Your Honor.
All right, thank you. Then I will sign the order and we will get it filed and processed, and all of you are excused.
Thank you so much, Your Honor.
Thank you. So then the next case is Miller. And Miller, let me know who's here on that, how long you need, and if you need a record.
Hi, Your Honor. Gregory Hitt, here for the movement. And my client is also here, Elizabeth Miller. She goes by Lisa. It's a motion for summary judgment. Ms. Miller is the respondent and counter petitioner in the underlying case. We have set it for 1 hour because it's non-evidentiary. I don't need a record, but I think Mr. Metcher has asked for a record.
Thank you. Mr. Metcher.
That's accurate. I'm representing Christopher Miller. He's the non-movement and the petitioner in the underlying suit. I would agree with an hour, although I'm asking this court to deny the motion for summary judgment, so it could be a lot less than that. We've got trial set in September.
Thank you. Okay, and then let me get a sense of the last case, the Thomas matter.
Yes, Your Honor. Good morning. This is Trey Dolezal. We set this on a de novo hearing because it should take less than 10 minutes. We just need some really access to the court to try to understand how this last motion for them to withdraw was granted without my presence. So we just need a few minutes.
So, okay, I'm kind of just getting oriented on this case. I know I received an email brought to me, and who else is here? Let me do that first. Who else is here?
Your Honor, my name is Dawn Archer. I'm from Bobby Newman's office. This is Mr. Dolezal's de novo of our motion to withdraw that was granted by Judge Arth last month.
And then it's your client. Who represents who? Because I got this email from what appears to be a pro se litigant, I think, and saying that she's not going to come.
That
I can clear that up, Your
Nina
Honor.
Thomas.
My name
that
is
the person that I represent.
Hold on. Okay, go ahead.
Your Honor, that's probably Nina Thomas.
It's
the client that I represented.
Got it.
That's correct.
I represent Earl Thomas.
Thank you. You represent Earl Thomas. You still represent Earl Thomas. Let me look at this.
Yes, I do.
All right. Thank you. Let me look.
And
Hold on. Don't talk yet. Let me look.
the main problem is, Your Honor, we have a.
Hold on.
Okay.
All right. I want to let you know what I received, because I believe this is an ex parte communication, and I'm going to send it to you, Mr. Dolezal, and I think you, Miss Archer, because you're at least appearing with regard to this hearing today. We need to forward this to you, I think, because it went to court administration, but I don't believe either of you were copied. But I'm going to read you what it says, since I have something that neither of you have access to, I think. This is from Miss Thomas. It was sent to Jacob Stokes and Warren Vavra, who are the court administrators in Travis County. It says, "My name is Nina Thomas, and I am scheduled to be on the docket call on July 11th, 2025. I will be unable to attend. I am traveling to Puerto Rico, and I am unsure of the Wi-Fi accommodations." That's all we have. We received it on Wednesday, July 9th at 3:11 p.m. And I received it about 5 minutes ago when court administration brought it by. So that is what I know from her. And given that, I have to go back and tell the other case about the motion for summary judgment in a minute. We're not on the record yet, Mr. Dolezal, but I did want you to know all of that, Ms. Archer and Ms. Dolezal. Do you still wish to proceed today?
Your Honor, we just need some clarification. I don't need a record on this. I don't exactly know what to do here. They're trying to withdraw. We have had a jury trial setting for a year on the 21st of this month.
Then we'll come back to that in a second. Let me, if we don't need a record, do you need a record, Ms. Archer?
No, Your Honor.
All right, then let's come back to that in a minute. Hold your thought, Mr. Dolezal. Hold that thought. Mr. Mesher and Mr. Hitt, he's here somewhere. There he is.
Yes.
Sorry, I lost you for a minute. Why don't y'all come back? I have this lunch out of the office at noon, and I think this case that's after you, I can probably finish before lunch, whatever we're doing here, but I think I'm going to have you guys come back at 1:30, and we'll do the motion for summary judgment at 1:30.
All right, Your Honor, that's perfectly fine. I just want to let you know I just filed a few minutes ago just a summary of what my argument is. So it's not really a new pleading or anything like that. It's just a summary of my argument.
You filed it just now. It probably won't make it to me, but if you want to send the 201.submission@traviscountytx.gov, if you want to send that email, a copy of it, and copy Mr. Mesher, you are welcome to do that.
Okay, I uploaded it to Box, but I will just send it to the submission.
Have it in Box. Then I do. I just want, if you found it, I didn't have it, but I can probably find it in Box.
Okay, all right.
So,
Thank you.
that's where I will look for it. Thank you. I'll see you all in a bit. Thanks.
Hey, Judge, we excused?
Yes. All right, now who do I have? I have Dolezal, Archer. I have Chris Miller. Is that somebody who's supposed to be here? I don't know.
Judge, I'm just chiming in. That's my client on the matter we're coming back for at 1:30.
Okay, good. I'm going to go ahead and remove him too.
That's fine.
Yeah, thanks. All right, we're still broadcasting on YouTube, but it takes some of my screens away that if I remove some of the people who aren't part of this case. All right, so here we are. We are back to this case. You are set. This is so interesting. For jury docket call with me on tomorrow morning, also by Zoom. I looked it up, so somebody here announced ready for that trial. And it's you're last on the docket, but it's not that long of a docket, so I don't, chances are you might get reached. Now let's go over what happened. There was a motion for continuance also filed, but all I see is that an order on the motion for withdrawal was signed.
Your Honor, that the motion for continuance was Mr. Dolezal's motion that he filed the night before. The transcript of the hearing before Judge Arth should be in your box if the court wants to reference that. Judge Arth was very clear that if Mr. Dolezal had an issue with the date, he should have filed his motion for continuance.
I mean, sorry, an issue with the date for your motion to withdraw hearing, right?
This is my hearing. Can I talk? She always does this. This is my hearing. I don't know why she has to take control every time.
Well, I'm going to mute you both. Okay, so, and then I will ask one of you to unmute when it's your turn to talk. That will handle that issue. So we have currently a jury trial set in this matter on July 21st. It looks to be a hearing noticed on a motion to withdraw for Miss Archer for her representation of Miss Thomas, filed and heard, and that is what we're here on the de novo on. And so now to you, Mr. Dolezal, you may explain to me what it is you're concerned about and what it is you want clarification on. You have in fact filed a request for de novo, so you have the floor.
Thank you very much, Your Honor. This is really quite simple. They set a hearing without discussing with me the hearing date at all, like they've done this entire case. They did not ask me if I was available. They didn't ask for available dates or non-available dates. They just said it. I immediately, when I found out, started emailing counsel for Nina Thomas, both of them, telling them that I was unavailable on that date, that I could not be on a hearing on that date. I let them know that probably 5 different times between myself and my assistant. They never responded, as they never do in this case. This is a very complicated divorce that we've been trying to get done for 3 years. It's been set for almost a year now. I am concerned that, number one, they're just doing this to manipulate the court's attention, and they'll get back into the case after this trial setting once Nina Thomas either says she's going to get new counsel or she can't represent herself. I don't know. But I filed a continuance the day before because I could not get anybody to respond to me on the other side, hoping that they would agree. Then we tried to get in touch with the court that morning. We couldn't get through. I was on an airplane. I told them that when they first said it, and they didn't talk to me about setting it at all. So I need some clarification on whether or not this jury trial can move forward, and that counsel that just withdrew cannot get back in once this trial passes, if it doesn't get reached or if somehow it gets continued because Nina Thomas is pro se.
I'm going to need to take a break because I need to ask my court reporter something, and she's in the other room, about this box that you say is there, Miss Archer. I need to try and find it for a minute. So give me 2 minutes. Let me see if I can find out where your box materials are. Thanks. And then I'll be able to come back. Give me a minute.
Okay, thank you.
All right. Back. Sorry about that. I found it. I think we just loaded it. She had just loaded it up, but when I refreshed and figured it out, I now saw the transcript from Judge Arth. So did you, it is a bit problematic to me, Miss Archer, that I can't see in your motion or in the transcript that it was that Judge Arth was alerted that the jury trial was right around the corner.
We had the conversation, and then when everyone was on the Zoom, Judge Arth and I had a very lengthy conversation about everything, and then he put me on the record and then came back to me to make his decision, and that's the only part that was on the record. Your Honor, I think it's important to note for the court that we have not been paid in 5 years. That Ms. Thomas, just as you saw from the email today, is not really being very communicative with us. We also were told by the court coordinator this morning to alert the court that we've not been receiving notices and things such as the Zoom link like for today since we had withdrawn. Judge Arth is well aware. We've been in front of him many times. I want the court to know that some of the things that Mr. Dolezal is alleging are the exact things that he's been doing, not this side. It's incredulous to me that he would say that he sent email after email after email telling us, I'm not available. We did not hear one word from him after we filed the motion. What Mr. Dolezal always tells me is file your motion for continuous, Ms. Archer, if you don't like my setting. So having said that, we do need to be off of this case. We have been off of this case. I'm asking the court to let us remain off of this case. Mr. Dolezal, in addition to making all of these claims, only filed his motion for continuance the night before the hearing, which Judge Arth was very clear that that did not meet the 3-day notice. And I'm asking the court, please let us off this case. We don't want to have a client that talks to us and we haven't been paid in 5 years.
Okay, so here's the thing, Mr. Dolezal. I understand you don't want this to be a backdoor way for a continuance of the jury trial. That's probably what you're here about to say, right? Like the reason you don't want her off the case is you want to go to jury trial the week of the 21st.
Well, yes, but
You don't want it. I mean, I don't have a lot of lawyers who are like, I don't want to be against a pro se person if strategically they can go to trial when they want to go.
right. I mean, that's the main issue, but let me try to nail this down. I can send you the emails that my office sent Miss Archer about us having a conflict. I will send them to the court so the court doesn't think I'm making that up, because I did. Number two, I think it's wholly unethical for them to go forward with that hearing without telling on the record that Mr. Dolezal told us he couldn't be available and he filed a motion for continuance, just so that at least Judge Arth would know that I didn't just ignore the fact that there's a hearing. And I find that really unethical and inappropriate. And the fact that she's claiming that I'm the one that's setting hearings, I could never get them to respond to any emails for 3 years. So that's just completely a fabrication. And yes, I am concerned about losing our trial date.
May I briefly, just very briefly respond?
Can I go first? Because honestly, I just want to get to the root of this here. So I don't think whether the hearing happened, how it happened or didn't happen, Mr. Dolezal, that's kind of, yes, we could have a whole hearing about what happened and didn't happen, what was told to Judge Arth and what was not told to Judge Arth, those sorts of things. But I kind of, because I just like to get to the end because I'm seeing you again tomorrow. And we don't have a person who is currently not represented here. I don't know if any of that's true or not true, but let's do some things. One thing I noticed in the file right away, Mr. Dolezal, is that this case has not been mediated. Am I correct on that?
That is correct. We could not get them to go to mediation.
Right.
That is correct.
Here's the thing. Tomorrow, I would kick you from the docket anyway, because I'm just telling you, you will not be going to trial on the 21st. Not because you haven't mediated, but because you haven't mediated or gotten an order excusing you from mediation. So if they won't come to mediation and you want to go, you have two things, right? You can file a motion to compel mediation, in which case I think a judge would grant that. Or you could file a motion to be excused from mediation because our local rules require it. And to get to a jury trial, you either have to have mediated or you have to have this order from a judge excusing you from mediation. So what I'm trying to do here is save your client some money, Mr. Dolezal, because if you show up tomorrow, I'm going to tell you that tomorrow, right? And she's not coming anyway tomorrow. So, because I've got this email from her saying she's not coming. So what we need to do, even though she's probably watching, is my guess. What often happens with people who are self-represented, they think their rights are better off not appearing sometimes rather than appearing. And so sometimes they watch this public feed on the YouTube channel rather than coming to the Zoom link. And listen, I've been on the family docket for what is it? Thursday? I've been on it for 4 days and I've already handled something like 10 self-represented litigant cases. And so the family docket is full of self-represented litigant cases. The jury dockets are full of self-represented litigant cases. For whatever reason, people think they're better off going to jury self-represented rather than going to a judge self-represented. I've rarely found that to be true, but that is what they believe, and it is certainly their right under the Texas Constitution, and so we don't take it away from them, but it is a very hard thing to do. What we need to do, because I think at the end of the day, to get to the end of the story, Mr. Dolezal, maybe you're right, maybe you're wrong. I don't really want to relitigate it because at some point, Miss Archer is going to get out of the case. We're not going to make her be on a case where her client's not responding to her and she's not getting paid and all these other things. I don't like the way all this went down. It feels a little like we maybe should have waited to my docket call before we got out of the case where there was a jury trial scheduled and announced and ready to happen on July 21st, but going to the end of the story and saving me time and saving you time, Mr. Dolezal, rather than you continuing to kind of beat your head against the wall. What I want to do now is I want to tell you that I think because this case has not been mediated or an order is on file, you're not going to have your jury trial the July 21st. So we can have it pretty quickly. Like, I don't want to delay it. Just because she's no longer represented doesn't mean you can't go to your jury trial quickly. We do jury trials a lot in Travis County with self-represented litigants. They're not particularly easy to do, but I've done them earlier this year. Judge Seufer did one earlier this year. I think Judge Cantu Hexel did one earlier this year. Like, it's happening more and more frequently. Whether or not it should happen or not, I don't know. But it seems to be a thing that's happening. So we do it all the time. So, again, we're in an ex parte hearing. I think we're in an ex parte hearing because Ms. Thomas has chosen not to show up. But I am telling you, we need to reset the jury trial. And then I think, and quickly, let's pick a date. We'll reset it. We'll get it quickly. And then rather than relitigating, if you had notice, if they should have had the hearing, if a withdrawal should have been granted, let's just get to the end of the story and recognize maybe we could grant the de novo and then do it all over again. But you're still not going to get your jury trial on the 21st. And eventually she's going to get her withdrawal because however this was done this time, it can be done eventually.
I understand.
Kind of where I am. It's sort of the practical answer to all of this. I'm inclined to just, mostly because it saves me time and ultimately you time and money, despite what I think are some possibly legitimate concerns here, I'm inclined to just deny the de novo, and then give you a reset date for your jury trial. And also we need to give Ms. Thomas notice of when that jury trial is going to be and when her appearance needs to be for docket call, because I'll do docket call by Zoom. But what do you think works for you?
As far as resetting for a jury trial?
Yes.
Well, that was part of the problem is I've got several arbitrations and jury trials the rest of this year, but I think I can find time.
Pick two different dates. Why don't you pick two different dates and
Okay.
we'll do a setting and then we'll do a backup setting. And so if it comes to court and says this date doesn't work for me, we'll say, oh, we already got a backup setting. So the new date works for you. And so we just need to look at the jury docket and we need to pick two dates. And then I'm going to call court administration and say, this is so is she the side that's seeking jury trial or are you the side that's seeking jury trial?
I think we both requested a jury trial, but it may be at this point, if she's pro se, that we want to do a bench trial. I need to have a conversation with her about that.
Well, the best thing to do in that instance is to still set it on the jury trial, because we have bench trials that happen every week and jury trials don't happen every week. And so if we set it on the jury docket and then the two of you discuss it and you both kind of say bench trial is better, and it might be at this instance because it gets a little rocky with it's just very hard to do with
I agree.
litigant, but she may not waive.
We'll see.
We'll see, but let's still do it on the jury docket, and then if she waives and you waive, we can move it to the family bench docket very easily.
Okay. All right. Can I get back, look at the jury docket today and send the court the dates that I am asking for?
Yes. So send me to me, copy her. Do you have her email?
I do.
And so say basically as a result of our hearing today, I learned that we will not be going forward with our jury trial on the 21st, and the court asked me to send 2 dates for my availability for a jury trial. And these are my 2 dates. And then, she can choose to respond or not respond.
Very good. Thank you, Your Honor.
But you have that 201.submission@traviscounty.gov. And so then we'll do it this way. And then Miss Archer, we don't have to get into it. You'll just be out of the case. And if you feel like, and it might not be a bad idea, that you need to respond to your former client with some sort of email communication because you did appear here today, I think that would be a good idea. But I recognize she is your former client, not your current client.
I will reach out and let her know through an email. At least I know then I've done my part by putting it out there.
All right, that sounds great. I recognize it's going to be difficult, Mr. Dolezal, and that you would have made those points had you could have appeared. But I just don't think at the end of the day it probably would have. Had we had a contested hearing, the only question would have been when the trial is going to be anyway, really. It wouldn't have been a no, in my opinion. So we're just going to move on to the next part of the story. So
Understood. Thank you, Your Honor.
Thank y'all. You
Very
are
good.
excused.
Thank
Very
you.
good. Thank you.
Let me take attorney announcement first and who you represent, and then I'll take the self-represented announcement. Go ahead.
My name is Carolyn L. Collins, and I represent the petitioner and movement, Lee Ann Duty.
And then we have the, I think, pro se respondent here with us. We call it 2 different things, Mr. Duty. It's both referred to you as an SRL sometimes, which is self-represented litigant, or a pro se litigant, which is just Latin for self-represented litigant. But you may make your announcement.
Just here to represent myself.
All right. And then I will say, I think your email address might be wrong in the clerk's. So we need to try and get that fixed. And I'm going to ask my staff, Ms. Jones, if she could email the clerks and let them know to fix his email to the proper email, because I think that would help this matter perhaps quite a bit. Somebody probably keyed it in wrong or an email got changed.
My last name is incorrect in the email that was sent.
Yeah. So Frenchie, could you please email the clerks and give them the proper email for Mr. Duty?
Yes, Judge.
Thank you. With that in mind, that may be part of the problem today. I don't know, but we're here on a motion for new trial, I think. And so, Ms. Collins, you may lay out your motion.
Yes, Your Honor. So this is a divorce case, and apparently it got put on the dismissal docket for want of prosecution, but I never received the notice. It's the first time. I've been practicing almost 40 years here, and first time I never received the notice. So the first I knew about the dismissal was on May the 22nd when I got an email from the clerk. It was a notice of dismissal order. So I contacted my client to see if she wanted to pursue the divorce, and she did. So we filed the motion for new trial and to reinstate the case on the docket. As you can see, this divorce has been pending for quite a while. It was filed in 2018, but back at that time, the parties had 2 minor children. And it's my belief that it's because now the children are both over the age of 18. And I think the parties have tried reconciliation maybe 1 or more times, and that's been the big delay in the divorce. But I will tell the court, I had drafted a divorce decree back in 2023. And so I took that divorce decree and I took out all the information about the children, because again, now they both aged out. And I sent that to my client to look at so that we can move forward and finalize the divorce without much delay here, Your Honor. So we'd request that the case be reinstated on the docket so that we can move forward and finalize the divorce.
And then, is there any worry about deadlines at all? Are we beyond, since there's no notice, I know that's the main issue. I'm not quibbling with you about the notice issue because we've been trying our best to get we didn't do DWAP for a while during COVID, if I'm just being honest about it. And we've been trying to get it up and running, but we have a whole new case management system. We have whole new personnel in the clerk's office. And so it's been a bit of a difficulty. So what you're saying, I don't even really question its accuracy because we've been having some difficulties with it in other areas as well. It doesn't really, I mean, at this point, effectively, I just don't want to deal with the plenary power issue, but let me hear what Mr. Duty has to say.
I did get a notification that it was being dismissed due to lack of warrant a while back, in which I received a letter. I did show that to my wife. I'm unaware of the 2023 creed. I've not seen any documents from Ms. Collins since 2018. I have only one question. If it's refiled, does it start anew or does it retro back to the original date of the first filing?
Do what? I'm sorry, what?
My question is, does it, if this is granted, does it start a new divorce case or does it retro back to the original filing in 2018?
And what do you think is the substantive difference? I'm just asking.
Okay, it makes a difference in my premarital assets and my pension.
I'm trying to think of how that would make a difference.
My understanding when we first went through this from my attorney is that my wife is not, is only allowed her share from the date we were married to the date of the filing. So that's adding an extra 8 years, which makes a questionable for me. I need to protect myself and my kids.
I'm gonna have to look at this. I do have issues with notice, but should it have been dismissed, Ms. Collins? We didn't prosecute it for 8 years or at least 7 years. I mean, what is going on here?
Well, I mean, I'm the first to admit it was sporadic. I mean, that there was probably very little that showed up in the court's file, because really all that happened is we filed the divorce. Mr. Duty did have an attorney for a while, but that attorney withdrew, and I'd have to look back and see what year that happened. But again, it was
2019,
kind of off and on because of the minor children and my client's, indecisiveness about whether she wanted to pursue the divorce. And like I say, I think there were even some attempts at reconciliation. Mr. Duty could speak more to that than I could. But
yes,
all I can say is that when I notified my client that the case had been dismissed and asked her if she wanted it to be reinstated, she said yes, and that she was ready to move forward with the divorce.
Okay. Have no objection to that.
I was having problems with my computer, so I wasn't able to look on which docket this one was given notice of or not. Oh, yeah. I'm gonna have to look over the file. I just have to look at it. I have to look and see what happened. I didn't realize that it would make this big of a difference. I don't know if it does or it doesn't, but that's a pretty significant difference, Ms. Collins.
But it doesn't. So they don't, as far as I know, they don't have a prenup or anything like that. And so the community property is created up until the date of divorce.
Yeah, it's not really date of filing that I know of either, Mr. Duty. I've never heard of it being the date of filing. I've always heard of it being the date of divorce. So I don't know that if there's something actually that you're thinking.
No, I'm just going off what my first attorney had spoken to me about.
The easiest thing to do here, I just need to look at the file. I need to look at the notice, etc. But I'm not aware of it having that big of an effect, Mr. Duty. But Ms. Collins, on your point, does it have really an effect either from your client if it was dismissed versus if you just file for a new divorce?
Well, it would mean having to pay filing fees again, prepare documents again, basically revise the ones I have to, she'd have more attorney's fees for preparation of a new petition for divorce or revising the old one. And then the 60-day waiting period would start again.
Yeah. This has been, when did you finally get notice of something? When did you get it?
I received it by email from the clerk on May 22nd, 2025. And it showed that the actual order of dismissal was signed on May 20th, 2025.
Yeah. Yeah, I think this was caught up in the a strange run that was done by court administration. Okay, let me just look at it, and will you send me the order that you wish for the court to sign? Copy Mr. Duty on it. Send it to the 201.submission@countytx.gov, and I will look at it and make a decision. I'll take it under advisement until I can make a decision. Okay. But it sounds like we're moving toward a divorce no matter what. It's just a question of whether it's in this old cause number or a new cause number. I don't see it having any sort of real effect other than the filing fees that you mentioned. But maybe I'm missing something. I don't think the law is what you think you remember your lawyer saying, Mr. Duty, but if you found something while I'm taking under advisement that was actually legal and not based off hearsay, that would be a substantial effect to granting this.
Okay. Well, my understanding.
Well, your understanding isn't like good enough, right? Like if you found.
Correct. I understand.
Yeah.
I'm just going with what I remember him telling me. One, I was in my pension 10 years before my wife and I got married. So my understanding that would be considered a premarital asset, not community property. Well, so from the day we got married until now, maybe it is all community. That's fine, but not the beginning.
We can't give you legal advice,
Right.
Ms. Collins and I, but there is a concept of before you're married, there is a concept of separate property. But while married, it's not really about when you file, it's about when you actually get.
Okay. Well, maybe it's under the assumption that we were going to end it at that time, and that's my mistake.
That probably has probably be true, but since you didn't, that's sort of the difference. Again, we can't give you legal advice. You need to talk to an attorney.
Yes. Thank you.
But I don't really see this having the perceived effect that you remember. But attorney, if I'm wrong, if we're wrong, I want you to have a chance to brief it and like send me something to the same email that you received from Frenchie Jones. You can send it to that. Ms. Collins copied on it while I'm taking it under advisement. When do I have to sign this by, Ms. Collins, to make sure I don't lose plenary power?
Boy, it'll be 75 days from May 20th. So that I don't know. I haven't counted that up, Your Honor. But
pretty close.
Are we past that?
No, we're not past that.
Okay, no, it's coming. Oh, you're right. I'm counting. I'll have to figure that out, but I'll calculate as well. All right, send me the proposed order, and let me look it through and look at the file and see what happened here, and I will let you know. Thank you.
Right. Thank you, Your Honor. May we be excused?
Thank you, Your Honor. Thank you, Ms. Collins.
Thank you.